you can't behave properly in a virtual courtroom, then I can have you come into the courthouse. Do we need to do that?
No.
March 2nd, 2022 at 9 a.m. for pretrial. All right, we'll see you next Wednesday, and you'll have a chance to talk to your attorney in the interim time period and figure out whether you want to handle this as a plea or if you want to actually have a trial. Ypsilanti Township versus Edward Ojanaka, case number 21T00205. Good morning, Mr. Ojanaka.
Good morning.
All right, we're here for a final settlement conference today.
Your Honor, there's an offer here of OWVI, which I had spoken with Mr. Ojanaka. I told him if he needed to speak with me again about it, I would request a breakout room. I'm assuming, but not sure, that the people are able to proceed.
Yes.
Mr. Ojanaka, did you need to talk with me again about that offer that we discussed?
Yeah, I'll take the offer.
Okay. The offer, Your Honor, and maybe Mr. Barnett, if you could, well, actually, Mr. Barnett, could you confirm that my notes show that there's an offer of visibly impaired?
That is correct. We would add account 2 of visibly impaired. That's MCL 257.6253-A. That's 93 days, $300.
Thank you.
And in return, we would dismiss the original charge.
All right, Mr. Ojanaka, as your attorney and the prosecutor have placed on the record, the offer is that if you would plead to operating while visibly impaired, a misdemeanor carrying a maximum of 93 days and or up to $300 in fines plus court costs, they would dismiss the more serious offense. Is that what you want to do, sir?
Yes.
All right, could you please raise your right hand to be sworn? Sir, you need to remove your hat also, okay? Thank you. All right, now raise your right hand. Do you swear affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you. I'm going to some rights that you have that you're going to be giving up today. Please let me know if you have any questions about any of these rights or stop me if you want to talk to your attorney, okay, sir? With respect to this case, you have a right to have a trial by jury. We're here today for the final settlement conference, and jury selection will be next week. You have a right at a jury trial to actually call witnesses to speak for you. You get an order signed by this court to require that any witnesses come to court. You have the right to see, hear, and question all witnesses that are called against you at a trial. You have the right to be a witness for yourself or to remain silent. If you chose to remain silent, the prosecutor cannot comment on that. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. Do you understand all those rights, sir?
Yes.
You understand that you'll be giving up all those rights by entering into this plea today?
Yes.
Do you understand that there will be no automatic right to appeal this decision? So the decision that you're making today is likely to stick with you, sir.
Okay.
And so you understand that piece, correct?
Yeah.
Mr. Ojanaka, you have to respond either yes or no, or
I said yeah.
If the yeah is not really an answer.
Yes.
Thank you. Sir, do you also understand that if you're on probation or parole, this could be considered a violation of that?
Okay. Yes.
On September the 13th, 2021, you were before the magistrate. You did sign an advice of rights at that time. Is that correct, sir?
Yes.
All right. Did you read that document?
Kind of, sort of.
Are you a United States citizen, sir?
Yes.
All right. To the charge of operating while visibly impaired, how do you plead, sir?
You said what?
To the charge of operating while visibly impaired, how do you plead?
I don't know. What am I supposed to say? Guilty?
You're supposed to say whatever you're choosing to do today, sir.
I don't know how this court stuff go.
Mr. Banners.
Your Honor, I know we're here for final settlement conference. I do believe Mr. Ojinaka wants to take the plea offer, but I don't think he's able to at the moment. So my suggestion would be maybe we could have a pretrial and we could do it there, and then I'll discuss all of this again with Mr. Ojinaka. I want to make sure he really understands what he's doing.
Okay. Mr. Barnett.
Yeah, I don't object to that. That's fine. That's
Thank you.
I'm gonna schedule this for April. No, I'm gonna schedule this for March 10th. No,
It's Paul's case. So we
Oh.
Wednesday.
we need a Wednesday.
Yeah.
What date is that, please?
Is that gonna be my last court date?
Or the 16th.
No, you're gonna come back for what's called a sentencing, sir.
So how many more court dates I have to come back to?
Mr. Ojinaka, I'm going to be calling you tomorrow and we'll walk through all of this again.
All right, I'm gonna put this on for next week.
Oh my God.
Sir, is there a problem? Sir, first of all, are you laying down?
You said what?
Are you laying down?
I'm at home.
No, you're in court, whether you're at home or not. Are you laying down? And if you can't behave properly in a virtual courtroom, then I can have you come into the courthouse. Do we need to do that?
No.
March 2nd.
March 2nd, 2022 at 9 a.m. for pretrial. All right, we'll see you next Wednesday, and you'll have a chance to talk to your attorney in the interim time period and figure out whether you want to handle this as a plea or if you want to actually have a trial. Bond in this particular case is continued.
Thank you.
thank you.
You are set, Mr. Ojinaka. You may leave, sir.
This courtroom moment starts off as a simple plea deal, but quickly reveals something far deeper: confusion, pressure, and a defendant clearly not ready for the decision in front of him. Mr. Ojinaka is offered a reduced charge, a chance to avoid a more serious offense by pleading to a lesser one, and at first he agrees. Everything seems to be moving smoothly, almost routine. But as the judge begins explaining the rights he's about to give up, the reality starts to hit. You can hear the hesitation in his voice. The uncertainty grows stronger with every question. When asked how he pleads, he freezes. "I don't know what I'm supposed to say." That single moment changes everything. It exposes a critical issue. He doesn't fully understand the weight of what he's doing. His own attorney immediately steps in, recognizing the risk, and halts the process to protect him. Because, in court, a plea isn't just words. It's a life-altering decision. And then, just when things couldn't get more tense, his behavior shifts, appearing casual, even laying down during a virtual court session. He's sharply corrected by the judge, A reminder that even in a remote setting, the courtroom demands respect and seriousness. In the end, the plea is delayed, not denied, giving him another chance to truly understand his choices. And that's the key takeaway here. In the legal system, rushing without understanding can be more dangerous than the charges themselves.